Hey, what's up, y'all? So, sometime back, I did a video, and that video was called Steve Greenberg Deals the New York Feds Yet Another Blow. I never followed that video up, even though I intended to. This is going to be the follow up video. I'm going to try to make it quick, and I'm going to try to condense a lot of information so that this video is short because I'm short on time myself, right? So, essentially, in the first video, I showed you how Steve Greenberg basically comes out and he says that the STD law in New York is unconstitutional. So in this video, we're going to get into the nitty-gritty details. We're going to make it quick. We're going to cut the fat and we're going to focus on the meat, right? So with that in mind, we go straight down to this paragraph, and he basically says the predicated acts alleged in count 1, numbers 10 and 12, as well as the Mann Act violations alleged in counts 2 through 5 rely on the New York statutes, namely New York Public Health Law Section 2307. This law was covered in the other video. And then it says the New York Penal Law Section 120.20. The public health law provides as follows. I'm not going to talk about this because basically, well, I'm not going to get into this. I'll just give a summary. Essentially, if you have a disease, you are prohibited from having any type of intercourse, right? So that's what this says. If you want to get more details, go and watch the first video in this series if you haven't already, right? And then he goes on to say this statute is facially unconstitutional. It prohibits intercourse by anybody who has an STD. The definition is vast, ranging from HIV to yeast infections. It includes HPV and scabies. And it says the only requirement is that the individual knows that they have the venereal disease. In other words, it prohibits two consenting adults from having sexual intercourse if either or both know that they have an infectious venereal disease. It does not require that the disease be passed on, nor does it allow the consenting adults to have intercourse if the venereal disease is disclosed, right? And then it says it does not permit the use of condoms or account for modern day suppression drugs, right? And then it says the New York Penal Code codifies, it says the New York Penal Code defines relevant sexual terms, right? So now this is where I find that the motion takes a very interesting turn. And basically what the motion does is that instead of stating a lots of arguments in the motion, he actually provides links which gives you more information on STDs. And essentially, when you look at these links, they pretty much make the argument for Greenberg, right? So one of the first links that he provided is the link for HPV, which I believe is the human papillomavirus, right? And in his motion and also on the link or on the site, it says 79 million Americans, mostly in their late teens, early 20s, are infected with HPV. And then somewhere here it talks about vaccination. It talks about vaccination, which will basically stop the spread of the virus and also suppress the symptoms. So that's one link. And then he provides another link which basically talks about STDs, particularly HIV. And he provides yet another link where he basically shows that HIV can be completely suppressed. And once it's suppressed, you don't even need to use a condom anymore, right? And that's basically Biktarvy. Biktarvy allows for the suppression of HIV. I'm not advertising Biktarvy. They should send me a check though, since this is in my video. But okay, what can I do? Anyway, so moving right along, these links, he's making the basic argument that STDs are common and they're in our society and there's ways to treat this. So this statute that you have that says people can't have intercourse because they have STD is unconstitutional, right? So I am going to scroll down and basically just make this video really quick. And he basically talks about substantive due process, right? So substantive due process are rights that the government can't really interfere with, or they have to be careful when they do interfere with it, right? So basically goes on to say substantive due process prohibits the government from limiting the right to engage in private consensual intercourse without fear of criminal liability. Private intercourse between two consenting adults involve a fundamental liberty interest that triggers a non-differential review when the government seeks to prescribe such contact. The principle, in its modern form, was first expressed by Justice Stevens in his dissent, the now infamous Bowers v. Hardwick decision, where the majority of the United States Supreme Court upheld the Georgia statute that criminalized the act of oral even between consented married adults in their private homes. Right, so that's really a crazy law, and apparently it went all the way up to Supreme Court. And basically, it's saying that you can't have oral in your own home, and this was in 1986. And the article, or the case law, implies that the two people were married, but the dissent made by Justice Stevens, and by the way, I think I did a search for him, and I believe this is Justice Stevens. Leave your questions, comments below if you think this isn't him, or you can confirm it is him. We want to know. So basically, he had a dissent, and he basically said it's unconstitutional and it violates the substantive due process, right? So I'll just go ahead and read it. I was going to skip it, but I'll read it anyway. Our prior cases make two propositions abundantly clear. First, the fact that the governing majority in the state has traditionally viewed a particular practice as immoral is not a sufficient reason for upholding a law prohibiting the practice. So just because it's immoral doesn't mean it has to be criminal, right? Neither history nor traditions could save a law prohibiting miscegenation. Neither history nor tradition could save a law prohibiting miscegenation from constitutional attack. Secondly, individual decisions by married persons concerning the intimacies of their physical relationships, even when not intended to produce offspring, are a form of liberty protected by due process clause of the 14th Amendment. Moreover, this protection extends to intimate choices by unmarried as well as married persons, right? So that was Justice Stevens' dissent in the Bowers v. Hardwick case, which was in 1986, and this went up to Supreme Court. And from my understanding, correct me if I'm wrong, but basically a dissent is when one of the Supreme Court justices disagrees with the decisions that the majority has ruled on, right? So it just so happened that Justice Stevens' dissent basically became a majority, or it became the law in another case where there was a situation where there was two homosexuals and they decided, that they wanted to have sex, which, homosexuals do. How dare they have sex, right? So they had sex and somehow it was found out and it went up to the Supreme Court in Connecticut, and basically it was overturned basically by the dissent that was the logic in the dissent that was made in the case Bauer v. Hardwick. I was trying to skip it, but I'll just go ahead and read it. In 2003, Justice Stevens' dissent became the view of the majority when the court ruled a similar law was unconstitutional. In Lawrence v. Texas. Justice Stevens' analysts, in our view, should have been controlling in Bowers and should control here. Bowers was not correct when it decided, and it is not correct today, right? And then it says Lawrence concerned a Texas law that specifically criminalized homosexuality. Lawrence's invalidation of the statute was not predicated upon any per se constitutional right to engage in the specific acts themselves or any particular act, but rather from application of basic constitutional privacy jurisprudence that has its origin and Griswold versus Connecticut, right? So basically the logic that Justice Stevens had in one case in 1986 basically is being reapplied as a majority in another case, right? Which is basically, an updated case, right? Actually, it looks like the Griswold v. Connecticut case was actually 1965. So I'm not sure why the logic didn't work in 1986, right? So that's pretty much it for this video. I'm going to cut it really short here. I think everyone gets the gist. Basically, substantive due process is when the government comes in and tries to regulate something that they have no business regulating. The government has to be careful when it starts playing with your fundamental rights. And this is the argument that Greenberg is making here. The right to have sex is fundamental, and when it's between two consenting adults, the government doesn't have a right to just come in and just blatantly take that right away. It doesn't matter if you have a STD. If another person wants to have sex with you, then that's that other person's decision. And basically, you can see from this video and several other videos that I've done. So you should go back and watch the video series if you haven't already, dealing with the R. Kelly herpes allegation. And in that video, I point out the fact, or actually a doctor points out the fact that, the herpes virus is extremely common. Many people have it and they don't know they have it. And in this motion, Greenberg points out that HPV is common. HIV is not so uncommon, but basically you can see that there's suppression drugs out there that basically allows you to have sex without a condom. So he's making those arguments to say that this statute is too broad and it's not specific and it basically takes a fundamental right. So thanks for watching. Leave your questions and comments below. I want to know what you think about people having sex with STDs. Do you think it's okay? Do you think it's not okay? Do you think New York had it right when they're saying, hey, look, you got an STD, you need to take a time out for life? Do you think that's a realistic approach, right? And if that person does have sex, then they're basically going to go to jail, right? Even though the other party consented to it. Leave your questions and comments below. I want to know what you think.